Ready.
So if we're ready for Whitehall and Ms. Wilson?
Everyone that intends to have give testimony at A1 Wilson, would you please stand to be sworn?
Dollarway.
Would you raise your right hands? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
It's okay. Go ahead.
I'm asking the state.
Identify yourself.
Oh, I'm sorry. My name is Laquita Wilson. I'm trying to transfer my daughter, which is LaAriana Wilson, from the Dollarway School District to the Whitehall School District. I currently have 3 children that are already in the Whitehall School District under the School Choice Act. And this is her first year as kindergarten, and I'm trying to transfer her in, and I was denied by the Whitehall School District simply because Dollarway rejected the transfer. I was informed through the Pine Bluff commercial that the only reason why Dollarway denied her application is because of cost only. They want the students that are in the Dollarway district to stay there so they could receive the funding for that particular student.
Any questions? Okay, thank you. Mr. Jones.
I'll wait.
Mr. Jones, okay. There was another gentleman that stood that wanted to speak, and I don't have his name. What's on? Oh, okay. Okay, Dr. Smith. Dr. Smith?
Yes, ma'am.
Would you identify yourself, please?
Larry Smith, Superintendent School of the Whitehall School District. We did receive an application from the Wilson family, and as she stated in there, she does have siblings that came into under the prior School Choice Act that are in our district. Dollarway has opted out of this one, so we did deny that request based on that opt-out.
Any questions? Is there anyone here from the Dollarway district?
Yes.
Come to the podium, please, and be sworn. Oh, he's not heard. You got to be heard. You got to put something else. Okay. Mr. Key has advised me that you are an attorney. So
Yes.
to proceed, and
Yes,
you
Madam
have been
Chairman.
sworn also.
Yes.
I'm Paul Bloom. I'm the lawyer for the Dollarway School District. This is Superintendent Patsy Huey.
And what's your superintendent's name?
Patsy Huey.
Proceed.
All right. Madam Chairman, the Dollarway School District does not participate in school choice primarily because it is still under the jurisdiction of the federal court in a long-standing desegregation lawsuit. In fact, that desegregation lawsuit is sufficiently old that it existed prior to the enactment of any public school choice act. The district did submit a letter to the department timely prior to January 1 with an information to the ADE that is the reason that we are opting out of public school choice. Now, Ms. Wilson said that our reason for opting out was monetary. Well, I mean, that's always a consideration, but that's not the reason that we opt out of public school choice, but we are still under that desegregation order. Now, whether there is a conflict, we can find out at some other point. As the AG's opinion pointed out, the ADE apparently, including the state board, apparently does not have jurisdiction to consider such matters, but is to be referred to, as it puts it, a court of competent jurisdiction, which probably is a circuit court in the county of the resident district. That has not been done. Furthermore, since the desegregation order predated the Public School Choice Act and certainly predated the amendment requiring a notice from a federal court of the actual conflict between the DSEG order and the Public School Choice Act. There has been no opportunity to actually address that issue with the federal court. We don't have any obligation under the law to do that until January 1 of 2016 regardless. But we have asserted that we are under the jurisdiction of the federal court and that we are therefore legitimately opting out of public school choice and therefore legitimately refusing requests for transfer out of the district. I know that under the law, the resident district doesn't have any say, all things being equal, and whether that student is transferred from the resident to the non-resident district. That's a non-resident district decision. But regardless, I think the issue is whether we legitimately refuse to participate in public school choice. And based on the law in effect at the time of the presentation of our opt-out letter to the department, we legitimately did so. So I think that our refusal in this particular circumstance to participate in public school choice is one that we have in good faith entered into. So we would request that the department and the state board particularly look at that and comply with the Attorney General's opinion, which is to say that if there is some disagreement on the part of the parent, that their resort is and must be to court and not to this board.
This is going to maybe sound really elementary, but here we are talking about school issues, so I think that's probably appropriate. But just to clarify, so a desegregation order is basically asking a district to do what?
Well, to cease to operate in a manner that segregates the races. And that's what the DSEG order in this case did. It's still in effect. The federal court retains jurisdiction. We have not been released from that. We have not been declared unitary. So we still have the federal courts ultimately to answer to.
And this might be for Ms. Huey. What is your percentage of African American students in your district?
We're over 90%.
Over 90%?
Yes.
And the family asking for the transfer is African American, right? So removal of an African American family from your district would not, certainly not, I think, affect the desegregation. I mean, I'm just throwing this out here because I think this is probably something we're all wondering about.
May I respond?
Mm-hmm.
Well, in the first place, the racial consideration was the thing that the federal courts have said that we may not use as a basis for a transfer or not. That is why the initial Public School Choice Act was changed to get rid of the racial component to that. So that's not a component of the Public School Choice Act anymore, and is not a consideration to be taken into account.
Yeah, I'm just making the point that I think we're all wondering about. So.
Right. Well, I understand that, and the thing is, even at that, your concern is something that is and this is according to the AG, and I think the federal courts would agree with this, that is not a consideration for the department, but that is consideration for the federal court as to whether participation or not in public school choice is in violation of the desegregation order.
Yes, under the Act law, I never know whether to use the word Act law or statute, so pardon my ignorance of the law. Under D2C on page 54 of ours, it says, shall include a statement that priority will be given to an applicant who has a sibling or step-sibling who resides in the same household and is already enrolled in the non-resident district by choice. So it's my understanding that 3 of the siblings of this entering kindergarten student are in the Whitehall district. Is that true?
That's our understanding. But at the same time, that preference under the law is something for the receiving district, the non-resident district, to undertake, not for the resident district. And for the resident district, as I've been pointing out, the Dollarway School District does not participate in public school choice, so that's really not an issue for the Dollarway School District.
So it is your position that because you have a law that was, or a deseg order from 59 and 68 that had to do with staffing, that you are denying a child in 2015 who already has 3 siblings in another district who is an entering kindergarten student that you've never served. You choose to stand with that old law to deny an African American kindergarten student to leave your district who's never been there.
Well, it's really more simple than that. We simply don't participate in public school choice, and as I indicated before, we're not per se refusing the transfer. We just don't participate. It's up to the resident, or rather the non-resident district, to grant or deny the transfer, and the Whitehall School District has deferred to the Dollarway School District because we don't participate in that, so the issue is fundamentally moot.
Ms. Huey, would there be any point in this parent talking to you and your board about a legal transfer?
No, ma'am. No, ma'am.
Well, basing on erring on the side of a child and a family and a parent's choice, I move to grant the parent's request and give priority to students who already have siblings attending a different district.
Heard the motion from Ms. Lip. Is there a second? The motion failed based on not getting a second. Is there, first of all, any other questions? Dr. Barker, you have a question? Any other questions? Is there a motion?
I move to sustain the denial of school choice.
Is there a second?
Second.
All in favor? Any questions? I think the parent is in the back with the question before we vote. Come forward. Ms. Wilson.
My question is, under the general provisions of the School Choice Act, it does state that a present or future sibling of the student who continues enrollment in the non-district under the school choice shall enroll if the district has the capacity to accept the sibling without adding teachers. And that is so in this case.
Ms. Wilson, not Ms. Wilson, Ms. Davis, about the procedure where we are now. Do we undo our motion in a second and go back and discuss this particular, or do we do it with a motion and a second on the table?
Baker can withdraw the motion that's on the table, so that way you can continue discussion, if you choose.
And is it the desire of the person that made the motion or the second to withdraw to discuss this particular point that Ms. Wilson has raised?
I thought the issue had been answered earlier. I'll withdraw if it would be preference of my colleagues. I will withdraw if Ms. Sabers.
Okay. Well then, Ms. Wilson, would you come back and give us that information again? And we'll start from there.
Under the general provisions of 5.03.1, it says a present or future sibling of a student who continues enrollment in the non-district under Section 5.03 of these rules may enroll if the district has the capacity to accept the sibling without adding teachers, staff, or classroom or exceeding the regulations and standards established by the law. A present or future sibling of a student who continues enrollment in the non-district and who enrolls in the non-district under this Section 5.03, these rules may apply and complete all remaining years at the non-resident district. I have, like I said, 3 that have been there for the last 4 years, so she already has present siblings there, and I was the 3rd applicant, so that would not affect the school by having to add any teachers or staff.
Dr. Smith, would you step forward again, please? Do you have any comment on Ms. Wilson's latest addition to her presentation?
Simply, I think it still goes to the point of the district participating in school choice, which they are not. And so that makes that point, in my opinion, moot. I also would state to you, as I did last time, that it's going to be a little heartbreaking, but based on the enrollment numbers that we have, I don't know that we have capacity at kindergarten at this point in time. And we have accepted other students from districts who are participating in school choice, as well as the enrollment projections we have from the state, which puts us, at least right now, over capacity. Now, until we get kindergartners all in place, we don't know how many of them for sure will be there, because I can tell you that there will be 1 or 2 parents who come in and say, I thought they were ready, but they're not ready, so I'm going to take a waiver for a year. But we also may have 5 that move in. So we can't tell you that definitively at this point, but they still are not participating in school choice in that district, so I still do not believe that provision would apply. But Mr. Bloom may better be able to answer that than I can.
Would you like to speak to that?
Yes, ma'am. Well, we're aware of the language, that language in the School Choice Act. In fact, I think we've discussed it during the course of this particular presentation. The thing about that is where these parents or children have preference presupposes that both the resident and the non-resident district participate in public school choice. Without that participation in public school choice by one or both of the 2 school districts involved, then the preference simply doesn't apply, because, as I said, it presupposes that there may be a transfer, and if one school district does not participate in school choice, then there may not be a transfer. So that language doesn't apply in this situation.
So, Ms. Davis, did you find out whether or not this district or one of the schools in this district is in academic distress?
It's just the school.
Commissioner Key.
Mr. Bloom, is it the blanket decision of Dollarway that the provisions of school choice in this case, every provision is in conflict with the desegregation order?
Well, I think that's a decision that we are not under the amendment to the law, that we don't make. That's a federal court's decision. As it stands now, we're operating under the previous law, which is why we submitted our letter, opt-out letter, to the department when we did. At this point, we have to address the question to the federal court, which still has jurisdiction of this matter. And even at that, as the Attorney General said, the department isn't the one to decide whether or not the level of conflict is adequate to enable the district to opt out of public school choice, but that would be a question for a court of competent jurisdiction, probably the circuit court in Jefferson County.
You talked about federal court. Does Dollarway intend to petition the court to determine what is and what isn't in conflict?
Well, Your Honor, if we're going to continue to opt out of public school choice from this point forward, I think it's obligatory that we do that.
Okay, so you're saying yes, and y'all are going to...
Well, as a lawyer, I'm trying to say yes. But, yes.
Just point out to the board that as in our research, we have found a provision in the standards, and in our review of standards, that is a component that the legislature put in law a few years ago, that districts, as part of our standards review process, the department is to look, and they are to be making efforts, if they have a DSEG order, to pursue unitary status. We are looking, Mr. Harvey and his unit are in the process of determining how to best reach out and get that information from the districts as part of our standards review process for the purposes of in our accountability units.
I agree with what you say, and I think if the Dollarway School District is declared unitary, that settles the question.
It's really comforting to me to know that, because unfortunately for me, there are occasions, and I'm not casting aspersions on Dollarway necessarily, but it feels like just an attempt to keep anyone from transferring out. And I think that's what we all want to see, a process that works better for families.
Mr. Harvey is here and can speak to that at the appropriate time if the members of the board wish to hear the work that's being done on that.
It seems like in the law that we are given, the public school laws that are passed, under 6/18/1906, it says a district that has a desegregation order can declare exemption or resume participation after a period of exemption. So the way the law is written that we are given to follow, it doesn't indicate in any way that a district has to exempt themselves just because there's a desegregation order. And of course, after January of 16, they will have to show, through a letter from the federal court, a genuine conflict, which is the attorney's right. We don't have that in place at this point. But the way I read 6/18/1906, there was never an assumption that a district had to exempt themselves, but rather that that could be a choice if they felt like it was going to pull them back into federal court. It is my position, obviously, that something that was done in 58 and 69, or 59 and 68, other than Brown versus Board of Education, is at this point speaking to something that is not in play here.
Dr. Barr? Okay. Any other questions relative to this, to A1? Okay. Ready for a motion?
I will move to sustain the denial of school choice in this case.
Is there a second? Second. Okay. All in favor? Any opposed? Okay. Unopposed. One opposition. So the decision is upheld to deny the school choice application to the Wilson family.
Thank you, Madam Chairman. May we be excused?
Yes.
Thank you.
Ms. Newton, would you repeat who voted no for the record?
Ms. Silk voted no. Dr. Barr made the motion and Ms. Sager second. I'm sorry.
Thank you.